Good morning, everyone. Thank you for joining us. I'm delighted to welcome you all to today's webinar and open Q&A, Best Practice and Challenges, Human Rights in Supply Chains, which we are delighted to be running in collaboration with Norway's National Contact Point for Responsible Business Conduct and for the OECD guidelines. My name is Grace Stensrud, and I am a program manager here at the UN Global Compact Norway. I'll be leading this webinar with my colleague and fellow program manager Leonie Goodwin, who will be leading the Q&A later. And we also have with us Solveig Davik, who's supporting on the technical side. We are delighted to welcome member companies from across Norway and to have representatives from both the member companies Yara and Deloitte joining the program today. As a worldwide business initiative, UN Global Compact's aim is to raise companies' awareness of the relevance of ESG issues to their operations and value chains, and to scale the global collective impact of businesses by upholding the 10 principles of Global Compact and contributing to the progress of Sustainable Development Goals, as you're all familiarized with. On the agenda for this webinar, we have a refresh on the OECD guidelines for multinational corporations on responsible business conduct, and we're going to hear more about the work of the National Contact Point. We will be hearing the experiences of Yara on structuring and working with human rights in the supply chains. And we'll also hear examples of challenges and how to solve them with Deloitte, and a brief forward-looking perspective on the CSDDD and Transparency Act changes. We will also be ending with a Q&A session. I'll also have a little bit of information. This first part of the webinar is being recorded, and both the slides and the recordings will be made available for you after the webinar. We have received your questions and input during the registration, but if you have any comments or questions during the webinar, please feel free to use the chat function. You can also upvote questions you would like the experts to answer in the chat. And these are the experts we will be hearing from today. We have Bondevik, who is a senior advisor from Norway's National Contact Point for Responsible Business Conduct and the OECD guidelines. We have with us Berg, who is a human rights manager at Yara. And we also have Kristina Krohn, who's a partner at Deloitte. I'll also introduce them more when they're going to speak, and we'll start with Per. As I mentioned, he's a senior advisor at the National Contact Point, Norway's Secretariat. He has over 2 decades of experience in international development, cooperation, business, and human rights, including being head of ethical trade in Norway for 6 years. So Per, you will give a quick refresh on the OECD guidelines and due diligence, as well as the Contact Point's mandate and role in Norway, and some practical insights, and link it with the Transparency Act. So I'll give the floor to you, Per.
Thank you very much, Grace, and good morning to everyone. Let's see if I can get the presentation up here.
Will you do the remote?
Oh yeah, right now I can't see the presentation, but might be my problem though.
Oh. We can see it here.
Okay, that's good. That's good. Yeah, there we are. Thank you. Sorry about that. Not the best start, but let's from there it goes only upwards.
Yes, it's fine.
What is the OECD guidelines? I guess most of you, of all of you, might have heard of them. I will not do the whole history, but it's important to remind that this is coming from somewhere. It started as early as back in 76. And then it's been through a number of updates and revision, and the last one was a rather large update was last year in 2023. Even more important is that this is negotiated. There are negotiated guidelines approved by the governments and by the representatives to the OECD, but it's a rather large setup of inputs, both from the OECD side, mainly through the OECD Watch, which is an international NGO coalition. Both the trade unions and the business have their representatives and the partners at the OECD, which are parts of all these negotiations. Just wanted to put this up to remind us all that these guidelines are are a result of broad coalitions and also of discussions among government representatives from the OECD countries and the other adherents. And as I mentioned, these are actually the guidelines are recommendations from governments to businesses. So all the governments who are part of the OECD and have adhered to the guidelines, they are committed to promote the guidelines and committed to develop policies that would support and encourage businesses to abide by the guidelines. These are the most comprehensive international ones on responsible business conduct, and of course are aligned with the UN guiding principles and the ILO conventions and other human rights and business-related instruments. Covers those 9 thematic areas where you can see there, ranging from disclosure to competition, taxation, human rights, and environmental issues, etc. And has one unique mechanism, which are the national contact points. I'll get back more back to them a bit later. But those are also part of the guidelines is the commitment of all the adherent governments to establish a national contact point to support and promote the guidelines. Some brief highlights from the updates in 2023. I will not have the time to go really into details, but there has been a stronger focus on climate change and biodiversity, keeping in mind that the previous update was back in 2011, and the world has developed quite a lot since then. Not surprisingly, there's more focus on technology, use of data, gathering of data, and how that is seen from a responsible business conduct perspective. There are stronger recommendations on the downstreams part, how the use of products or services, how to take that into account in proper due diligence. And also like to mention that there are stronger recommendations on lobbying activities, and also there's been done some work on strengthening the last point on the bottom right, strengthening the national contact points towards it's also framed as functional equivalence, with the aim is to challenge governments and encourage governments to work for the national contact point to have a more similar way of operating and more comparable functionality. As you, I guess, you will also know, there is thing happening on the legal side. These are the main developments there of the last 14 years, going back to 2010 when the US Dodd-Frank Act on conflict minerals. I would say when it comes to the due diligence, human rights due diligence, which is at the core of the OECD guidelines, the French law from 2017 is often seen as the first one taking that properly into account. Then we have both in Holland and in Germany, and of course in Norway back in 2022, and with the CSDD that came last year. And all of these refer to and build on the OECD guidelines and the OECD guidance on due diligence. A bit more on the Transparency Act here in Norway. This might be familiar to most of you, but just it's worthwhile to reiterate the purpose of the Act. It's to promote the enterprise's respect for fundamental human rights and decent working conditions. So it's twofold. And the second point, it's about public access to information. The first one is more directly linked to the OECD guidelines. And as you know, there's at the moment it's given the scope, it covers around 9,000 Norwegian companies and organizations. And I often say, and I think that's right as well, that but for practical purposes, it would impact quite a lot of more companies. because part of the obligation for proper due diligence is also to follow up on your supply chain. So all those smaller companies who wants to supply big companies or public entities will somehow be affected of the requirements in the law. I guess many of you smaller companies listening today will also have been receiving questionnaires and in different ways from your forms from your clients, where you're answering questions that they then again use in their due diligence and mapping the risk and how to deal with that. So this is a quote from the Norwegian Transparency Act to carry out a due diligence in accordance with the OECD guidelines for multinational enterprises on responsible business conduct. But what does that actually mean? This is the way kind of summing up what the due diligence means. Maybe well known for many of you, but the first point important. And we're talking with companies, and when we were looking into specific cases, we see that the point number one, embed. What does that mean? That means that you need a top level commitment from CEO, from board, saying that this is something that we want to do. We want to integrate this in how we do our business. Without that first step, you might end up with having some idealists in some parts of the companies doing as good as doing their best, but still the normal running is not really affected by the responsible business approach. So this is a really important point. And we see that those companies who really succeed in integrating the human rights perspective in the way they work, it always requires a top level commitment across the system. Second point, an obvious one in a way, identify and assess adverse impacts. What does that mean? Does that mean that you need to map everything that might happen or have happened, or where there's risk? In an ideal world with no limits on resources, I'd like to say yes to that, but still, in real life, you need to prioritize. You need to look into doing, let's say, some key questions you can ask. Are there critical supplies we know that are coming from areas of the world where human rights is at risk, or where there's a non-functioning state? Are there well-known risks in the sector that we might need to look more into? Do we have long-term relationship with specific suppliers that we might work closer with? So you might need to prioritize it in that area. It could be due to volume, or it could be based on, as I mentioned, risks to the sector. Seize, prevent, to mitigate, step number 3. Well, the words explain themselves, but then again, you have to look into what are the critical risks and to whom, how severe are the risks to those that might be affected, and what can you do about it? Are there ways of collaborating with other companies in the sector, across sector, with trade unions or with NGOs that might provide you useful information, or that might help you in designing a way of mitigating the impact? And the same goes for tracking and communicating what's happening. One of the key challenges that we see in the cases we sometimes work on is kind of is relevant for several of these steps, both on mapping and designing actions and following up. And that's the consultation with local communities, who do actually represent the local communities, who to talk to, and how to manage that and deal with that information. And then again, I like to just remind, I think from my experience as well, working together with other companies and with other actors from other sectors is often one way of dealing with that when it's hard to get through, kind of identify and know who to speak with and which information to trust. Well, yeah, let me see next slide. That's also one important point with the Transparency Act. It's written not as a comply or kind of a mainly a comply or not act, but it's intended to be a process, and that's also a key kind of characteristic of a due diligence. This is an ongoing process, to have to be adapted to the proportion, the size of the enterprise, the nature of the enterprise, and also the gravity of the adverse impacts that you might find, or the potential impact. So a huge company would have a different process than a small one, but still looking at the same issues. Next slide, please. Yeah, a bit about the national contact points. There are 51 national contact points around the world. As you see, there's the OECD countries and some other non-OECD countries that have adhered to the guidelines. We have 3 main tasks: promote the guidelines, which is what we're doing now, and we have training courses, we participate in events, etc. Handle specific instances. Anyone could file a case or file a complaint with us, and from anywhere in the world that involves a Norwegian company or based in Norway. I'll get back to a couple of examples of that a bit later. And then also new in the 2023 update of the guidelines is our contribution to policy development in our both internationally and nationally in our countries. And there's a lot of tools and guidance coming from the OECD on both sector-specific issues and some cross-sectoral as well. All of these are available for free at the OECD webpage. We also developed some tools and guidance in Norway, a collection of dilemmas and examples, tables of human rights, what kind of human rights are included here. And we have made a brief introduction to human rights due diligence, also available in Norwegian and on our webpage. Other tools, the Responsible Business Conduct Compass is an easy-to-use self-assessment tool. It could be a good way to start, covering all the issues in the guidelines. So we'll be working the coming months on an update to the 2023 guidelines. This is also accessible on our website. And we do training courses, often jointly with the Norwegian Consumer Authority. The next ones are some forthcoming now over the next months. They will be launched, I guess, the coming days. And these are available to register within a limited number of places there. Specific instances, briefly, some examples. The first one is from the National Contact Point in Netherlands. The second from Australia. In the first one, the parties, and this, when we do a specific instance, as it's called in the OECD language, our job, what we do there is first to identify if it's within the guidelines, are the complainants, do they have a legitimate interest, and then our task and our mandate is to facilitate a dialogue, mediation, with the aim of the parties to come to an agreement. We have no authority to impose anything on either parties. Sometimes parties come to an agreement, which is the best case. Sometimes they don't. In these 2 cases, they did and agreed on compensations in both cases. Yeah. A recent one that we are working on as we speak is from southern Chile. It relates to hydropower development and rights to land and access to land, and what happened with the land when the dams and the hydropower plants are built. Some key issues that have been raised here is it's around consultations and proper due diligence and how to involve indigenous peoples and ensuring that their rights are taken into account in projects like this. The initial assessment that we just published a couple of weeks back, we concluded that this is a case that merits further consideration, and we offer our good offices, as it's called in OECD language, which means that we will facilitate and do our best to set up a framework where the parties can meet and hopefully discuss and come through mediation, come to an agreement on the next steps forward. Yeah, I think that's about my time in brief. The OECD guidelines, all relevant legislation coming up now builds on those. Due diligence is the key at the core of the guidelines. And our role is to provide guidance and facilitate access to remedy through the specific instances and facilitating dialogue and mediation.
Yeah.
Thank you.
Thank you so much, Per. That was very interesting to get some more insights into how you work at the National Contact Point and with the OECD guidelines. We'll continue on. And the next speaker is Lisa Berg. You work as Human Rights Manager at Yara, and that includes implementing human rights due diligence, ensuring that human rights considerations are integrated at all levels of corporate operations. And you will be sharing how you structure the human rights work at Yara and how you work with human rights in the supply chain. You'll also share about some of the main challenges in this work. So I'll give the word to you, Lisa. And while you're getting ready, I just want to mention that please use the Q&A function to ask questions if you have any. But then the floor is yours, Lisa.
Thank you so much, Grayson, and good morning, everyone. And thank you so much for inviting me to participate. I think this is a very relevant topic these days, and it's very nice to be able to share a little on how we work with this at Yara. So I thought I'd start just by giving a little overview of Yara as a company, just to give some context, and then I'll go into some specific examples on how we do supply chain due diligence. And then I thought I'd finish off with a few examples of challenges that we are facing and working with currently. Good. So just first, a little on Yara as a company. Yara is a global crop nutrition company. So this means that we produce mineral fertilizers, and we have a global presence. We have about 160 countries with sales. We have operations in about 60 countries and about 18,000 employees around the world. And our global sort of presence and operations means that we also have quite a complex supply chain, where human rights risks are present in everything from sourcing of raw materials used as input to our production, with third-party suppliers providing transportation, logistics, warehousing, bagging activities in connection to our production sites, and also in our sales activities and agricultural outreach. And the complexity and magnitude of all this really means that we need to have a risk-based approach to how we conduct our human rights due diligence in order to make this task manageable. And Yara sources from roughly 30,000 suppliers worldwide. So how do we conduct meaningful supply chain due diligence and ensure that we are applying the correct measures towards the correct suppliers in a sense? And I think one main point is really accepting, like Per also mentioned, like our due diligence measures cannot cover everything, right? but it can help us identify potential and actual impact, and it can help us make informed decisions. And we have several due diligence measures in place to help us do exactly that. Starting broad with kind of conducting geopolitical and human rights risk assessments to get an overview, kind of what does our business look like? What is the risk picture and context that we are operating within? And then we have our IDD process and supplier compliance management process to identify human rights risk exposure and manage compliance in the supply chain, sort of throughout the relationship with the business partner. And then we have our ethics clause and code of conduct for Yara's business partners included in our contracts, really setting, what is the Yara standard in relation to our human rights expectations. And then we also conduct human rights impact assessments. And these primarily focus on our own operations, but they also include contractors working on our sites and also include third-party providers of logistics and transportation, warehousing, packaging, bagging, blending, etc. So relevant to include in our supply chain due diligence measures. So I'll go into a little more detail on these in the next slides here. So like I mentioned, I think it's crucial to kind of start with getting an overview. What is the big picture here? And the inherent risk exposure in the fertilizer business is high. Sourcing of key raw materials and serving kind of main agriculture markets requires us to operate in many countries with high geopolitical risk, and also means that we have suppliers and customers then in high-risk countries. And we need to effectively manage this risk, right, to be able to deliver on our mission of responsibly feeding the world. So we cannot stay away from all challenging areas or challenging business partners, but it really puts additional pressure on us in terms of assessing whether we think we can have a defendable presence in a country or a defendable relationship with a business partner. So we have to consider, okay, what do we want the Yara standard to be? And then have due diligence measures that can help us assess that on such a large pool of suppliers. So our geopolitical risk assessment looks at risk across two dimensions. So firstly, what is the geopolitical risk picture in the country? Also including human rights and labor rights risk, but also looking at corruption and sanctions and political and government stability. And then we look at, okay, what is Yara's presence in that country? Do we mainly have sales activities? Do we have a production site there? Do we also source raw materials from that country? Or do we have presence kind of across the value chain? And then countries have been allocated into certain archetypes depending on the risks in these two dimensions. And within that archetype, actions are defined. So based on processes and procedures and activities we already have in place, and looking at are there additional activities or actions that we need specifically for those countries in a given archetype. And this is continuously monitored and updated and really helps our ethics and compliance department to kind of guide the business on, which countries do we need to focus on, which business partners within that country might need additional attention in terms of in-depth IDD or additional monitoring or supplier audits, or just dialogue and communication and more of a collaborative approach or training. And like I said, we mainly use our IDD, or integrity due diligence process, along with our supplier compliance management process, to identify our human rights risk exposure with our business partners or suppliers. And for those not familiar, IDD is the process of assessing the integrity of a business partner, also on human and labor rights risks. And the purpose is, like I mentioned, to help us make informed decisions regarding a business partner. So any new or potential business partner has to go through an initial risk assessment, also looking at potential red flags or known integrity risks or country risk. And then if any risk factors are present, an IDD is required. And that essentially means that the business partner has to fill in a questionnaire, which also includes human rights topics. And then any potential risks are reviewed by the Ethics and Compliance Department along with the business who wants to engage with this business partner. And then once the business partner is in our system, we have transactions and are working with his partner. They are continuously monitored against regulatory and compliance databases throughout the entirety of that relationship. So if any red flags pop up during that relationship, then Ethics and Compliance will reach out to the business and then go into dialogue with the business partners to see what additional measures might be needed. And then our supplier compliance management process defines the minimum criteria for selecting and qualifying and monitoring of suppliers. And this includes activities like the IDD process to help in selecting and qualifying suppliers. But the IDD process doesn't reach all. It doesn't reach that full pool of 30,000 suppliers. So we need additional measures to kind of help us get a better understanding of our risk picture, also within our existing supplier base. So starting with 30,000 then, we apply sort of various filters to kind of help us narrow it down to a manageable pool of suppliers that we then follow up and monitor more closely. So input used to this can, for instance, be country risk, including on human rights specifically. We will look at industry risk, we'll look at spend, we'll look at IDD risk scores, EcoVadis risk scores for those suppliers who have that. And then the supplier risk score in total is weighted then based on country risk and industry risk, giving more weight to that than spend, for instance. And then based on the final score, we end up then with a list of high-risk suppliers that are in scope for supplier audits, for instance, or EcoVadis action plans or in-depth IDDs, etc. And then I also wanted to bring up human rights impact assessments as a form of supply chain due diligence as well, like I mentioned in the beginning. Because although they have, like I said, focused on our own operations, they also include elements of our supply chain. And these types of exercises, and we've used external subject matter experts for these, they've really given us some kind of aha experiences and has really been an eye-opener for us in many cases. And sort of identifying that if we have risks on our own sites, there are bound to be similar or other risks at the sites of our business partners. And this also means that we have more knowledge on what to look for, and has meant that we can go into dialogue with our business partners and say, you know, look, these are issues on our own sites. Can we kind of have a dialogue or guidance around how to improve your site as well? And I think it really also increases knowledge in our business because these types of projects involves various internal stakeholders. So we get many more requests and questions to us after a project like this internally, because our employees now have their kind of radar or human rights lens switched on. So I think that's very valuable. And then to mention some challenges ahead, there are numerous ones, but I think to mention some, I mean, with so many direct suppliers just in our first tier, how do we kind of know that we are applying the correct measures to the correct suppliers? And I think some of the things we are doing to kind of mitigate this is to have established a supplier risk forum internally, where we have members from various departments to kind of sense check our approach and the final risk of, or the final list of high risk suppliers. We are also members of a sector initiative called Together for Sustainability, where we can also share learnings with other members. We can share results from supplier audits and EcoVadis results. And then also having several due diligence measures in place, I think is a good way to kind of sense check, and means that we also reach a wider group of suppliers. And in terms of raising the internal awareness level, I mean, we have new regulations and laws coming at us now from every angle, and an increasingly challenging geopolitical risk picture. So this really puts additional pressure on us in terms of having good enough due diligence measures, and also on the business line who are out there every day, right, engaging with these types of business partners. Because our procedures can't capture everything, and there's often not a black and white answer to dilemmas that we might encounter. So the more employees sort of know and are aware and know what to look for, the more we can kind of push actual change. So we focus a lot on training and communication to the business on kind of what are the human rights standards out there now, what are Yara's obligations, what are relevant human rights risks to look for, human rights in a Yara context, and what they can do if they suspect breaches. And then we also have specific training modules for the procurement employees in particular. In terms of actual improvements, I think this is kind of the main point, really. This is why these standards and laws exist. But actually ensuring this and also measuring actual impact, I think is quite challenging. Some of the actions that we've put in place this year is to create an audit follow-up forum, also with members from several departments, in order to really go into the audit findings, to try to prioritize, to see kind of what are the root causes, and assist the procurement managers in going into dialogue with the business partners to actually follow up that actions that are implemented are effective. And then another specific example is to kind of formalize the way we do human rights impact assessments, which also includes certain suppliers, like I mentioned, to kind of get this into a formal plan, do, check, act process wheel to ensure that actions that we implement, we actually go back and talk to rights holders and try to measure the effectiveness of the actions as well. And then on the regulatory requirements, we all know more and stricter requirements are coming. So we just have to continuously monitor this. We have an internal sustainability network with members from different departments where we discuss and see, okay, what do we have in place now? What is coming? How do we need to improve? And then we also have a specific CSDD project to look at the requirements and what is needed to comply with these new requirements. So I think I'll leave it at that. Thank you so much for the time.
Thank you, Lisa. That was very interesting to hear, and thank you for going into specific and details about how you work with the human rights in the supply chains and how you structure your work internally. Thank you so much. We'll move on to Kristina Krohn, who is a partner at Deloitte, and you lead Deloitte Norway's work on the Transparency Act, human rights and social sustainability. And you have extensive experience in managing social responsibility in supply chains, labor relations, and workplace crime across both public and private sectors. And today you will talk about how to meet challenges when working with human rights in supply chains, and briefly looking ahead on the CSDD and Transparency Act changes. So Kristina, the word is yours.
Thank you, Grayson. Thank you for the invitation, and also thank you for the introduction. I was asked, as you introduced, to say something about challenges and how to meet them. And I'm sure you can tell also from the presentation from Lisa and from Per that addressing that in 15 minutes is quite challenging because this is a really, really complex area. So for those of you who are expecting like a magic spell or a magic wand or something, I must disappoint you because there are none. But I think both Lisa's and Per's introductions gave really, really good advice in terms of, you know, what are the challenges, how are ways to approach them, and what is really important about what are the important considerations when doing the due diligence. So I also think you will find that some of the points that I bring up will mirror some of those that are already mentioned. But please also feel free, or I look forward to looking into your questions also afterwards. So when I'm going to say something about very briefly a recap of what due diligence is, what is some key principles or some best practices and some lessons learned in terms of actually being able to do those good practices. And then I'll say something about current and future regulations on human rights due diligence. So this is just a very brief recap, and this is the Deloitte version of the same process that both Lisa and Per referred to. The reason why I also bring it up here is just to highlight the importance of understanding that this is a process. The due diligence is not a one-off exercise. It is not something you can tick the box of. It is a continuous process, and it entails a lot of different steps, not only assessing risks or not only checking or doing audits of your suppliers. And the reason, of course, why businesses have a role in this is that, you know, states have the main responsibility of protecting human rights, but businesses has an individual responsibility to promote the protection of human rights. And that is, as mentioned earlier, it depends, of course, on the type of business that you have or the types of challenges or risks that you're facing. I think it's important also to note that when doing human rights due diligence and talking about human rights risks, we're talking about risks to people, risks to right holders, and not really risks to the business. But that is one of the challenges that I see, or how to, you know, kind of integrate these two, because they are increasingly interlinked. And it's also, in practice, it is hard to kind of separate the one from the other when prioritizing your efforts. And that is one of the kind of dilemmas that we often see. Some key principles for due diligence, which I think also illustrate, you know, what are some best practices? What are the key principles to follow if you want to do this in a responsible and good way that is also in accordance with the purpose of the Transparency Act and the OECD guidelines. The first one I've already touched upon. So due diligence is an ongoing process to identify, assess, prevent, or mitigate and remediate adverse human rights and sometimes also environmental impacts which are connected to your business operations. It cannot be seen as a one-off exercise. It is a continuous process, and it needs to be treated as such. And therefore, companies are expected to have clear policies and processes in place to manage human rights impacts and risks throughout their entire value chain. That means also that it's not sufficient to have like a human rights policy that you publish on your website. This needs to be an integrated part of the core business and of the relevant work processes. And also the next point here, prioritization of issues. Lisa was also mentioned that, also Per, it's really, really important that you actually prioritize, that you can't treat all your suppliers as one. You really need to look into where are the largest risks and how can we put our efforts into actually doing something about them. Other than spreading our resources very, thinly out throughout all suppliers. And when you do prioritization, it's the severity that should have the most weight. That means the scope, scale, and remediability of an impact. But that is, I will get back to some of the challenges in adhering to these principles, because that is really where some of the dilemmas arise. Meaningful stakeholder engagement. I said earlier that human rights due diligence is about managing risks to people, managing risks to right holders. And in order to actually address that, you need to know the views and the experiences of the rights holders and of the stakeholders involved. And this is a point where we see that it's really hard for businesses to understand, how can we approach this? How can we get this into a systematic process, actually engaging stakeholders in a way that isn't just a tick the box exercise at best. Then I think also a very important principle that wasn't touched upon that much earlier, that is that your responsibility as a company, it depends on what kind of relationship you have to the issue. And the OECD guidelines, they separate between 3 different types of relationships, and those are really important in understanding also the prioritization and how you address the risks. So if you cause the negative impacts, then you have a very large, of course, responsibility to do something about it, to stop the negative impact and to remediate. Whereas if your connection to a negative impact is through your supply chains, and even almost indirectly through your supply chains, then that of course gives you less leverage and less less opportunities to manage the risks, and you need to tailor your actions according to what kind of relationship you have to the impact. Then you have the communication, which is a really, really important part of this as well. Both communication to the stakeholders that you're dealing with, and also to the public. And the communication should be well enough to understand whether you're doing an adequate job or not. These are some key principles, and they're easy to understand, when you read them this way, that it makes sense to do it this way. But what we see when we work with clients in these types of processes is that there are challenges related to adhering to all these principles. And I think it's really hard to say, what is the way of dealing with those in a generic way, because this applies to businesses across sectors, across sizes, across what kind of core businesses you have. And that also means that there is no one-size-fits-all approach to dealing with this. And I think what Lisa described is a very tailored and good approach for the kind of company that Yara is, and also the kind of operations and supply chain that Yara has. And then, of course, this will look completely different also for a small company or a small or medium size enterprise in a very different sector. And as mentioned earlier, that is also one of the purposes of the Transparency Act, that you should have that room for maneuver in terms of adjusting to the specificities of your own business. So looking at some of the challenges when it comes to dealing with these key principles, what we often see when working with this. Well, the first one I touched upon already many times. There is a lack of continuity in the process. I think many did this as a first one of exercise when the Transparency Act came, and then forgot about it, or it kind of something else took the attention, such as the CSRD reporting, for instance. And then you did the first job trying to comply with the Transparency Act, and then somehow it just you weren't able to keep up the continuity. And one of the reasons for that is the lack of integration into core processes of the business. And what is specifically relevant in this instance, of course, is how do you integrate due diligence or human rights considerations into the procurement and supplier follow-up process. And I think Lisa gave some really, really good examples on how human rights considerations should be done all throughout that process. From the very beginning, from when you make a tender, for instance, what are the requirements you put into that tender? On what basis do you evaluate potential suppliers? What kind of contract provisions do you include, code of conduct, etc., that your suppliers need to adhere to? And then how do you monitor your suppliers according to risk? We also see that there is also often a lack of clear policies. As Per mentioned, those companies who succeed in this area, they have very clear top management anchoring. Many lack clear policies, or they have some kind of high-level policy, but it's not really clear in terms of how do we relate to these issues? How do we weigh these kind of risks and impacts against other strategic priorities and risks? Because it's easy to say that you have a zero tolerance, for instance, but what does that mean? When do we stop having a relationship with a supplier, for instance, if we find any negative impacts? Those kinds of policies, having those in place and having done that job before you find any negative impacts is really, really important. Lack of prioritization, this is maybe my key point. We see often that many companies do a bottom-up risk assessment. They don't do this, they lack kind of the umbrella to say, you know, what are the key risks for our business, given the context that we operate in. I think Lisa gave some really good examples on how Yara has tracked that throughout their processes. What are the key risks that are relevant, and what information on what grounds do we do those priorities? And what we see here is especially, you know, how do you ensure the traceability or the visibility beyond tier 1, for instance? And often that is really challenging. There are some systems that are helpful in that respect, but none of them are perfect. And I think the first step would be to understand your value chain, to see, you know, what are where in your value chain are the risks likely to occur. Lack of stakeholder engagement, I already mentioned that. How do we get the information we need? Lack of effective risk mitigation. How do we address the risk? If we find any risks, how do we address them? What is our toolbox? Many have supplier audits as part of their toolbox, but not necessarily much more than that. Not necessarily knowing or having clear policies in terms of how do you act on the risks that you see. And also, as Lisa mentioned, lack of data of effectiveness of the efforts. How do you know what works? How do you know if you have actually identified the risk? How do you know if the actions that you put in place are effective? And how do you know that the people who are affected actually are better off after you did your actions? That is a really, really difficult thing to address. And then lastly, how much do we want to share? I think that is also a dilemma for many companies. I think the regulations say, you know, you should share pretty much as much as you can. But many companies find that challenging in terms of other kind of strategic considerations, or how open should we be about the risks that we face. So these are some key challenges that we often see. I will just briefly end my presentation by saying something about the regulatory landscape. Some of this has been mentioned before. There are various EU regulations now addressing from different angles the need to do human rights due diligence. The CSDDD is was adopted this year. Will include obligations for companies from 2027 and onwards. But that is quite similar to the Norwegian Transparency Act. There are some differences here that I've included in the material that I think you will get access to later after the webinar. But for many Norwegian companies, this regulation will be, you will find some of the same wordings that you have in the Transparency Act. What many companies are in the middle of right now is the implementation of the CSRD and the reporting standards. And it's important here to note that the difference here is that the CSDDD says something about the processes that you need to put in place. So it says something about what you have to do in order to reduce the risks, whereas the CSRD is more of a reporting requirement. So for the CSDDD, many of the reporting requirements will be done through the CSRD reporting. But it's really the CSDDD that obligates you to do some actions. Whereas for the Transparency Act, that is, it's been into force for a couple of years. And it is quite similar to the CSDDD, but it's currently under evaluation to see whether it works the way that one expected, and also to see if there are a need for changes, given the provisions of the CSDDD and given also the experiences of the companies who have been subject to the law. So, for instance, we expect that they will consider including more environmental due diligence requirements, given that the CSDDD also requires that. I think I spent my time already, so I will stop there, and I can address any other questions in the Q&A if anyone has them. Thank you.